And welcome back, everybody. We're finishing today's show out in Los Angeles, where the fate of former That 70s Show star Danny Masterson is in the hands of a jury for a second time. The actor is charged with raping 3 women at his Hollywood Hills home in the early 2000s. All 3 women are former members of the Church of Scientology. Masterson had been a Scientologist for much of his life. He was initially tried on the charges last fall, but the jury couldn't reach a unanimous decision. But it was revealed that more of the jurors favored acquittal than a guilty verdict. His retrial started in April, with the prosecution getting the green light to bring in additional evidence. They argued that Masterson drugged his victims before raping them. All 3 women testified about their alleged assaults for a second time. They mentioned becoming unusually groggy and having gaps of consciousness after consuming drinks that were made by Masterson. Masterson's attorney, Philip Cohen, made it known that the charges are not related to drugging the women, and no forensic proof of drugging was shown in court. Cohen said he doesn't believe there's a grand conspiracy, but rather that the victims' stories could have been tweaked. The alleged victims have pending civil lawsuits against Masterson as well as the Church of Scientology. Thursday marked the second day of deliberations in the case. Masterson faces up to 40 years in prison if convicted on all 3 counts. So, Terry, the judge didn't allow certain evidence in the first trial, but is allowing the same evidence in the second trial. What's the justification for doing that?
Well, it's hard to see what the justification is. In the first trial, the judge did not allow evidence of drug use. He did say that the victims could testify about how they felt, but they could only testify about that and nothing else. No testimony came in because drug use and drug adherence was not something that was being charged in that case. The second issue was Scientology. The judge didn't allow any experts to testify about Scientology in the first case. In the second case, the judge said you can introduce an expert, and that expert can talk about whether or not this Scientology had anything to do with the women and why they didn't bring it up at first and the policies under that particular religion. And so the judge said she thought it was relevant as it related to consent or use of force. So none of the facts have changed and none of the law has changed, and yet the judge is allowing this information and this evidence to get in. You have to wonder why she's changing her mind during the second trial when nothing in the case has changed except her decision.
Well, Brian, if Masterson is convicted, what happens then?
So, Jesse, I'm a far more jaded than Terry when it comes to this, because the public defender in me says I know exactly what changed. The judge saw that a conviction wasn't going to happen because, to your point, they were leaning towards acquit. The numbers were 10-2, 8-4, and 7-5 in favor of acquitting. So now if these 2 fundamental things are changed and Masterson is convicted, I think the defense has a very strong argument to say, when this evidence didn't come in, looked like my client was about to get acquitted, or at least close to that. When the judge allowed this to come in without any real justification for changing it, this information biased my client. It shouldn't have come in. It didn't come in the first time, and now he's convicted. So what's the major difference here? I think it makes for a great appellate argument if he's convicted, and maybe they win.
That's a good, interesting legal argument. We'll see if it gets there. And welcome back, everybody. Tiger Woods is back in the news for developments off the golf course. The multi-million-dollar claims filed by his former girlfriend, Erica Herman, have been tossed out of court by a Florida judge. Herman accused the golf superstar of sexual harassment and asked the court to throw out a 2017 non-disclosure agreement under the Speak Out Act. She also challenged the validity of the NDA itself. This followed a previous lawsuit against Woods Trust, claiming a violation of an oral agreement between the couple. That agreement allegedly let her live in Woods' Florida home rent-free for another 5 years in exchange for, quote, valuable services. She says that Woods instead tricked her into going to the airport so he could lock her out of his Florida estate for good. The release of the NDA was part of Herman's strategy to keep both litigations in a Florida courtroom, but the judge didn't buy her sexual harassment claims, calling them, quote, vague and threadbare because Herman failed to provide any factual basis for them. The judge also considered the NDA to be valid at face value. The judge ultimately ruled that Herman must adhere to the agreement and all matters have to be taken up by an arbitrator instead of the court system. So, Brian, we know it's a big win for Tiger Woods, but how big of a win is it? Because could he still lose in arbitration?
Let me put it this way, Jesse. It's like he's 2 under par, so it's like an eagle. And here are the 2 points. One, if the NDA still exists, then more likely than not, there are terms within that NDA as to how this case needs to be litigated through arbitration. Oftentimes, the person who writes the NDA gets the better benefit of it because they get the benefit of how the NDA works, while the other person gets the money. And Tiger Woods would just pay her off to make it work the way that he wants it to. The second part that puts us under par, it's not in the spotlight. Tiger Woods doesn't want to air out his dirty laundry, so keeping the secret and following the rules that he put out there makes it way better. Now, if she comes back with actual sexual allegations, could be a bogey for him.
You want a little golf clap for that, for all those puns? But Terry, I'm going to go to you. The court said that the sexual harassment claim lacked specificity. What type of details should Herman have alleged?
Well, you actually have to put all the details in an allegation like that. So sexual harassment is any unwanted action against somebody, and it has to be either really persistent, or it has to be offensive, and it has to interfere with their work environment. She's claiming she was working for him. Now, I think you have to really wonder whether or not this was a work environment or whether or not it was just some sort of living arrangement. It is very unclear to me based on what they're saying. She should have had the dates, the time, the places. She should have had exactly what he did, how many times he did it. And so that's the specificity the court was looking for, and that's why the court said, no, this is too vague, it is very threadbare, and it is dismissed.
Well, for Tiger Woods, it's a big win on a legal front and a PR front. We do have some unique crime news for you right now. The man accused of stealing a pair of the ruby slippers that were worn in The Wizard of Oz is officially facing charges. That's right, Terry John Martin was federally indicted this week, accused of taking the shoes from the Judy Garland Museum in Minnesota almost 20 years ago. The shoes, estimated to be worth more than $3 million, were recovered during a sting operation in 2018. But the feds hadn't named a suspect until now. Martin was indicted on one count of theft of a major artwork. Garland wore several pairs of ruby slippers when filming the movie in the 1930s, and only 4 pairs are known to still exist, including the ones that were stolen in 2005. Since the shoes were recovered, they have been in federal custody as evidence. Judy Garland fans are hoping they can go up for display once again when the case is closed. And some good news out of Texas. On Monday, officers in Fort Worth responded to a call about a kidnapping. A woman said a random man jumped into her car and drove off with her 6-month-old inside. A search started, and just about an hour later, officers found the car and arrested the suspect, but there was no baby. Body cam video shows the moment that officers spotted the child in his car seat, safe.
Hey, we have the baby at 3600 Reynolds.
Oh, okay. Oh, it's okay. It's okay. It's okay.
Now that is a great ending.